coming right up, another update on another ruling from the Honorable Chief Justice Christopher Hinkson when it comes to whether or not British Columbia's discriminatory vaccine passports were in fact constitutional. Drea Humphrey here with Rebel News, and just the other day I brought you an important update about the judgment that was handed down on a case that was brought forth by our charity partners, thanks to your generous donations to that case and many other cases that you can find that are fighting for medical freedoms to be restored in Canada at our special website called FightVaccinePassports.com. Now, this report isn't about that case. You can find out exactly what happened there. I will go ahead and link that report in the description box below for this report. Bear with me. This report is another update from a ruling from the same judge for a very similar type of challenge, except this time it was brought on by Jeremy Maddock, a Victoria, BC man who is a legal researcher. And he also challenged the vaccine card orders to a certain degree and wanted to know if, in fact, they were constitutional as per Section 7 of our charter. Now, we're going to sit down and talk to Mr. Maddock, and I'll put the whole ruling for you guys to see again in the description box below. This is just one of 5 of the hearings that were heard in the spring that I took you to, reported on, and made sure you were up to date on, that I am now following up on. So make sure you have given us your email at rebelnews.com and you check back regularly to see what's been happening in Supreme Court, because let me tell you, the state-backed legacy media has not been covering these stories. Here's Jeremy Maddock.
So I challenged a public health order called the BC vaccine card. This was an order that required individuals to present proof of vaccination to visit a number of public venues, most particularly, in my case, restaurants.
Yeah. So we're all familiar with what that is, certainly if you live in the province of British Columbia. And there was also, would you describe this as a challenge against the vaccine passport? Because I know Justice Hinkson is saying basically it wasn't.
Well, the BC vaccine card, I was challenging a particular iteration of that was passed in or declared in December of 2021. And the reason why I chose that particular incarnation of the order was it was made after it had become very clear that the vaccine wasn't preventing transmission. And indeed, after Dr. Henry announced publicly that every British Columbian would, in all likelihood, be exposed to COVID-19. So at that point, any doubt on that question, in my view, had been cleared up by the science, and it was pretty clear from Dr. Henry's own words that requiring people to be vaccinated at most would provide a personal benefit to them. It would not provide a communal benefit to prevent COVID from spreading.
Now, in the case that I've already covered about Justice Hinkson's recent judgment on the Democracy Funds case and the one that we're connected to with Rebel News, it seemed as though Justice Hinkson just sort of had a short, I'm not even going to go there when it comes to whether or not these plaintiffs' constitutional rights were infringed upon. Your judgment has a lot more pages. It's a little bit more in depth. So how would you summarize what the Chief Justice's ruling was in this matter?
Well, what it came down to, and the right that I asserted was breached, was Section 7 of the Charter, which protects the right to life, liberty, and security of the person, and not to be deprived thereof except in accordance with the principles of fundamental justice. And the right to liberty has been interpreted as encompassing medical autonomy. So medical autonomy can include the right to receive treatment that you want or need. So it's been used to justify medical cannabis dispensaries, for example, have been upheld as that you can't ban those for people who really need medical cannabis. And on the other side, there's the right to refuse medical treatment that you don't want. So think Jehovah's Witnesses and blood transfusions, for example. Even though there's no doubt that blood transfusions have some medical efficacy, a person who sincerely opposes them on religious grounds has a right to say, no, you're not doing that to me. And an adult of sound mind can make that choice. So that's the general principle of medical autonomy in the Charter. We also have a principle called freedom of mobility or freedom of movement, which is also under Section 7. So that's this idea that you can you have a right to roam where others roam in your community. And that was decided in a case called Haywood, which was where there was a criminal law that said convicted sex offenders were not allowed to attend public parks and beaches and bathing areas, that kind of thing. The Supreme Court found that that was an infringement on the right to liberty because it prevented these individuals from roaming where the public is free to roam. And then, of course, the next step in the equation there is they say, well, is this in accordance with the principles of fundamental justice? That means it can't be arbitrary, it can't be overbroad, it can't be grossly disproportionate. So in that particular case, Haywood, they said, well, there should be some restrictions on the movement of sex offenders, but not to the point where they can never go to a public park again. This goes further than necessary. So I used that precedent to say, hey, if you're gonna stand up for the rights of sex offenders to move around the community, how about law-abiding people who just made a slightly different medical decision than what the provincial health officer would have us make? And yeah. I felt like I was on pretty strong ground with that argument. Unfortunately, the way that Justice Hinkson dealt with it, he conceptualized liberty very, very narrowly.
Now, in both of the cases, the one I already updated people on, which they can find in the description below, and then your case, you guys were kind of comparing, checking to see if these charter rights align with our charter rights. I think you did Section 7, and then you guys wanted to see how that paired. So what did you think of Justice Hinkson's ruling in regards to how you were viewing it? And yeah, what's your opinion on that?
So just to get to the nub of the decision, though, what he said at paragraph 77, he said the petitioner is clearly entitled to accept or decline even life-saving medical treatment, citing the number of cases that I referred to. Mm-hmm. But then at 78, he goes on saying, however, the order does not compel or prohibit subjection to any form of medical treatment. The order may make the decision whether or not to accept medical treatment in the form of vaccination more difficult, but it does not impose a decision on the petitioner. So essentially what he was saying there is that because I had the right to make a decision and did ultimately make my own decision, that my right to liberty was not impacted or engaged, which means essentially that the government, if this precedent stands, can make your life as inconvenient or unpleasant or uncomfortable as it wants to, without infringing your right to liberty, as long as it doesn't actually force you down and stick a needle in your arm, that it's somehow that your rights are being respected. And that's why I say that's narrower than I would have than I argued, right, and narrower than I would go if I were the judge.
Now, both of these cases so far that we're covering right now at Rebel News wanted to know how these infringements on people's rights compare against Section 1 of the Charter, which says that there can be sort of reasonable infringements on us. Now, Justice Hinkson, in your case, says that he did find the decisions to be reasonable. What's your thoughts on that?
Well, he didn't actually get to the Section 1 analysis because he said Section 7 wasn't engaged. So he sort of dodged the ultimate question of, are these measures arbitrary, overbroad, grossly disproportionate? A measure that's arbitrary is likely to fail the Section 1 analysis because it's not rationally connected to a pressing and substantial objective, it's called. Whereas a measure that's overbroad is likely to fail the Section 1 test as well, because it's not a minimal impairment. And these are concepts that have been fleshed out quite effectively over the years in Supreme Court of Canada case law. So, but I mean, the point was Justice Hinkson didn't get to that analysis because he said that my right to liberty wasn't infringed, therefore I don't have to do this analysis. I think any reasonable person who did the analysis on some of the examples I raised, like employees of restaurants not being required to be vaccinated, whereas patrons have to be. So you can spend the entire day in a restaurant touching people's food and talking to people. But at the end of the day, if you want to have a burger and have dinner after your shift on the outdoor patio, your unvaccinated coworkers would be required to escort you off the premises. Those kinds of things are so clearly arbitrary But by saying liberty doesn't apply here, you don't have a right to go to a private premises in the first place. That's just not part of liberty. Justice Hinkson essentially avoided that second stage of the analysis where he has to consider the merits of the decision. I exhausted my internal remedies by writing to Dr. Henry, seeking that she reconsider the vaccine card program at the first iteration of it, because the academic literature, even back last fall, was showing that it didn't prevent transmission. So I was saying this is unreasonable to dictate people's medical decisions when it doesn't affect anybody else. It doesn't prevent the spread of the virus. She didn't respond to my request. And then she put out an order saying that she wasn't going to respond to any requests because apparently her office received over 800 such requests. So I challenged the idea that the provincial health officer can just refuse to respond when there's a statute that says people can submit reconsideration requests and the provincial health officer is supposed to consider them and respond to them. And not doing that, I said, was unreasonable. He showed a great degree of deference to Dr. Henry and said that she was receiving all these requests. She published an order giving reasons why she wasn't considering them, and then that she didn't have to consider them on their individual merits, because obviously their public health resources were stretched at that time. I don't doubt that that's true. But on the other hand, when you make a decision that's that controversial, that has enough that 800 people are writing letters, I mean, that's a lot of people to be taking the time to actually put together an argument or a letter or try and lobby the health department. It's probably the most letters they ever got about an issue. So when you have a statute that says they have to do reconsiderations and you get that kind of response, they should have been prepared and had some way of streamlining this and dealing with all these reconsideration requests, was my argument. And I still feel that just ignoring people in a time of crisis seems like not very accountable governance.
Right, exactly. That's when we need public health the most. Now, the case is dismissed. What are your plans with this next? Or do you have any plans to appeal it or come up with something else?
Well, there's a 30-day appeal period, so I have until October 12th to make that decision. I'm hoping to speak with some of the other petitioners who brought similar cases and talk about strategy going forward. I'm inclined to appeal myself because I feel that the conception of liberty was so narrow. It set a precedent where we're whittling away at some of the most core rights in our Constitution, and I'm very uncomfortable with that. I'm also mindful of the fact that mandates might come back at some point. If we get a bad COVID surge over the fall or winter, or even if we have a bad flu season, this could allow the government to mandate flu shots, for example. And that's something that is unprecedented in our society. So I do think that there's a lot of appetite among people who have to see an appeal and to clarify these legal issues, and it might have to go higher. If mandates do return and there's an appeal pending, there would then be the opportunity also to go to the Court of Appeal for what's called a stay pending appeal, which would then cause the mandates to be potentially set aside if a justice agreed that I had a sufficiently strong case and that I was being harmed by the mandates, and there would be the possibility to continue the fight. So I'm looking at that. I haven't made a final decision yet on what I'm going to do, but I'm certainly weighing the merits and the possibility of an appeal.
Well, there you have it. Let me know in the comments what you think about this update. It seems, according to Mr. Maddock, that Justice Hinkson still, even in this case, didn't quite go into analyzing whether or not these vaccine passports are in fact infringing on people's rights. So, of course, I will be giving you more reports on if any of these cases go to the appeals. Make sure you go to rebelnews.com, or more specifically, fightvaccinepassports.com, because that's definitely where you can find out about these types of challenges against medical tyranny across the country. And it's also where you can chip in a few bucks to make sure those cases, those legal fights keep happening.